Do you want to come in on that?
Well, just picking up from, if I'm hearing correctly, Mr. Inglesi, what you've accepted is 2 points. Firstly, that you accept Hmrc owes a duty to Parliament and to the Public Accounts Committee. That's correct.
I have said that...
You just said it, but
I said it's part of our functions properly to assist Parliament, and we've taken a view that it's lawful to pass...
No, just please stick to the question. I mean, it even says at page 5 of the 19th October letter, so this isn't a trick question. Hmrc recognises that it is part of its functions properly to assist Parliament. So could we just stick, please, to the questions? I thought you'd already accepted this point.
Yes. Yeah.
Could we just go again? So do you accept that Hmrc owes a duty to assist Parliament and the Public Accounts Committee? Yes or no?
Yes.
Good. And do you therefore accept that information can be provided which is non-identifying?
Yes.
Yeah, and I thought that's the 2 points we got to with the chair. Where does the legislation draw a distinction between identifying and non-identifying information?
Because the legislation looks at each disclosure.
Now, can you refer in the legislation? Where in the legislation is a distinction drawn between identifying and non-identifying? Can you tell me which section that is?
That's the context of the legislation. So
no, it's not. There is no distinction.
Sections 18 and 19, and that is the advice that we believe is right, that we've confirmed with First Treasury Council. So that is our legal advice, and it's the advice we act on. But
sorry, can I come back to the question? The question: there is no distinction drawn. Can you take me to the section which draws a distinction between identifying and non-identifying information?
It stems from...
Can you take me to the section?
It stems from the notion of what one is disclosing, and so one has to look at each disclosure, and that is the point of the 2011 letter.
No, the 2011 lists 5 policy reasons, Mr. Inglesi, which I will come to and we can go through. Chief amongst those is it having an effect on voluntary compliance. But it does not draw a distinction, the Act does not draw a distinction, on my reading of it, between identifying and non-identifying. So the department is putting forward 5 policy reasons, which we can come on to, but in law there isn't a distinction, is there?
In law, one has to look at the specific piece of information that is being disclosed.
There is no statutory justification for the distinction, is there? There are policy reasons, perfectly reasonable policy reasons, why you may want to take a decision not to disclose, and we can come on to the policy reasons. The letter from Mr. Hartnett sets out 5 policy reasons, but there's no statutory justification for distinguishing between identifying and non-identifying, is there? In statute.
The sentence, pardon me, the sentence which I read out is the sentence that says that we look at each specific piece of information when it is being disclosed.
So I'm asking for the law. In statute, there is no... Can you take me to where in statute it defines a distinction between the two?
I think the best answer that I can give is that one has to read the whole of this letter to get the context.
The letter is not, with respect, Mr. Inglesi, the letter is not the law. The letter sets out a range of factors which are policy considerations. What I'm asking you is, from a statutory perspective, where in statute does it say? What we've got here is we've got a door, and the door says where there's a gateway, which is, if you have a duty to assist Parliament, you can provide information. And in the case of this committee, the gateway is open. But in statute, there isn't a distinction between those two things. And referring to the letter, it's a totally different issue to what's in statute. Do you accept that in statute there is not a distinction drawn? You're General Counsel, as I understand it, for Hmrc.
Yes, I'm the General Counsel.
Yes. So as the General Counsel of the department, do you accept that in statute there isn't a distinction between identifying and non-identifying information? Yes or no?
looking at the context of the legislation, there is a distinction.
So can
And
you
you
take
have-
me to the distinction?
Well, I can take you to it if you would like by looking at the letter.
No,
if
the
I can-
letter's no good.
It's the Act.
There's
Town legislation
there is
is a
nowhere in
term.
law that it distinguishes between those two things, does it? What it is policy consideration. And we can come on to the policy considerations,
is-
but in statute you're not prevented
No,
from
it
disclosing.
it is more than policy.
Where?
Yeah, I think
you're a lawyer.
if you have the patience, I must refer you to the parts of the letter which I think are very clear.
Honestly, Mr. English.
The
Just a
letter,
second, a criminal offence, I mean, parliamentary privilege applies. The Bill of Rights would apply in terms of criminal offence. In any event, we haven't gone into the detail with Vodafone, but that's information in the public domain in any event. I mean, that gets us into the issue of the policy decision. I mean, even the letter from Mr. Hartnett, I mean, accepts the point. It says, where there is a power to disclose, which is obviously different from the position taken by Sir Gus O'Donnell in the 2009 letter to Edward Lee, where he said, we can't disclose much as we would like to do so. He's saying here, where there is a power to disclose, a decision whether or not to disclose must be taken in respect of each identified piece of information. So there's an acceptance in this letter. And indeed, it talks about the need to reach, in summary, a reasonable decision. So the point is, in law, you're not preventing from disclosing. The point is the department is taking a decision, which it's perfectly entitled to take, a decision at its own discretion as to whether it discloses. And what we then need to establish is whether that decision is being exercised reasonably or not. The point being, you're not prevented in law from disclosing.
as I was saying before to you, there are two levels of this. One is it part of our function to disclose non-identifying, to disclose identifying information? And there the letter says that it doesn't follow that it is properly part of our functions, and the question whether it would be so is far from free of doubt. And because of the potentially criminal context in which the question arises, the department, therefore, it's entirely appropriate for the commissioners to take the view that they don't want to run that down.
You're saying criminal sanctions apply. We're talking about passing information to Parliament. Parliamentary privilege would apply.
It's also necessary to look at the other provisions of the Act that, for example,
No,
demonstrate...
you're going off onto another point. Your point was criminal sanctions apply. But surely this is covered by privilege.
No, it's important to look at the other provisions because, for example, we comply fully with the NAO. We expose all our papers to the NAO. The NAO have constraints on them, but powers to disclose.
But again, it's a totally different issue. You've no choice over that. The NAO has the right to demand whatever information it has. I mean, we covered that last time. So that's absolutely irrelevant as to how you exercise your discretion. You have no discretion in terms of the NAO. The NAO, by law, can ask for whatever information it requires.
And I know I haven't come into the second level yet. So the first level, it's entirely proper for the commissioners to take the view that this isn't a function because of the advice.
What
that
isn't a
Well, it's here. I've got a
comment
copy
on that
of
letter.
the Goldman Sachs one. I mean, it's very interesting. We may come on to as to why you issue proceedings in the county
From
courts,
the
which tends to
minutes.
get less reported than in the High Court, given the value of the sum. But I mean, the documents are here, so they are a matter of public record. As is the data that's in the Vodafone accounts that shows the amount of assets it had.
I don't want to move the content yet. We're still on process.
So again, it's a policy issue around where you're arguing various sort of policy points around the impact on voluntary compliance or the issue around prosecution of officials. These are policy questions. I'm very happy to spell out why I don't think they apply.
What do I do?
But we haven't addressed the starting point, which is the legal position.
If I come on to that level, there's an issue that is set out in the letter that says that if it were the case that a function existed, that function, that power would then still have to be made in a way that was consistent with both public law principles and the department's statutory obligation.
Just on the chronology, could we just clarify, what date did you first become aware that a mistake had been made?
The 7th of December.
The 7th of December. So when Mr. Hartnett, 2 days after shaking hands or not shaking hands with Goldman's, or 3 days rather, it was the weekend, he had his meeting on the Friday and spotted, he said, the mistake on the Monday, he didn't get in touch with you at that point?
I believe he got in touch with me as soon as he was able to.
The 7th of December?
I don't think anything turns on that.
So
but I think...
No, because I think the chronology is quite interesting, because I've always found it odd that whether the mistake was spotted before or after the meeting on the 30th of November. So could we just go through the chronology? The meeting was held on, I think, the 19th of November. Well, why don't you take us through the chronology? So the meeting with Goldman Sachs and Mr. Hartnett was on what date?
I believe it was the 19th of November.
19th of November, when the deal was done. And yet you didn't learn of the mistake until the 7th of December. And yet you're the chief lawyer advising on whether this is a binding or non-binding deal. Okay. Could you just talk us through what happened between the 19th of November? Who first brought it to your attention? When did you first learn of a mistake having been made?
The 7th of December.
Okay, and who brought that to you? Was that Mr. Hartnett or one of your lawyers?
No, Mr. Hartnett.
Mr. Hartnett. He didn't tell you which case it was. He just said one of the cases.
He might have done, but we have... I'm not trying to be funny, but we've got 8,000 cases.
No, I appreciate that.
If I don't need to know...
Could you clarify, ahead of today's hearing, did you read the minutes of the 30th November meeting?
Which meeting was that?
That was the high-risk group meeting, which I think was held on the...
Yes, I think I've read that. I don't have them in front of me, but I think...
I presume there is a detailed minute of that meeting, is there?
I can't recall now. I don't have it in front of me.
Okay. Well, it's difficult to read it if it doesn't exist, but one would assume a meeting of that gravity would have a minute taken. I mean, do those meetings usually have minutes taken?
Yes.
Yes. But you haven't read it prior to coming today?
I have read it, but I don't have it in front of me now.
Right. Okay. So it does exist. Were any of your team at that meeting?
Yes.
Okay. And did any discussion take place around the Goldman Sachs deal at that meeting?
Yes.
So was the mistake spotted or discussed at that meeting on the 30th of November?
I believe so.
Okay, so the meeting on the 30th of November, the mistake had been identified then, more than a week before Mr. Hartnett telephoned you.
Mr. Hartnett spoke to me on the 7th of December.
Sure, okay. Did no one from your team communicate that a mistake had been made on something of this gravity between the 30th of November and the 7th of December?
Did anybody from my team tell me?
Yes.
No.
So your team, your lawyers, went to a meeting where they established that a serious mistake had been made, but they didn't tell you as General Counsel?
My lawyers are appropriately senior and they can engage on this sort of thing if necessary. They don't need to tell me everything.
Sure, I appreciate lawyers are involved. I would assume lawyers drew up the contract. So it's a statement of the obvious to an extent that lawyers were involved. What I'm saying is you alluded to in terms of your answer to the Goldman's meeting on the fact that you have very senior lawyers who you give discretion to as a result of their expertise. And are you a tax expert yourself?
I'm not what you call a tax lawyer.
No, right. And the three lawyers you've hired, the three people beneath you, are they tax experts?
The three directors that I have who have come to work for HMRC under fair and proper procedures rather than people that I've hired are not what you'd call tax lawyers.
Experts. Okay, so you're not. I'm sure it was a fair and proper. I wasn't suggesting it was a fair and proper. What I'm just establishing, we discovered at the last hearing that there's only one tax commission who actually has detailed knowledge of tax, and what you're saying is General Counsel and the 3 senior lawyers hired, none of which are tax experts. So coming back to the Vodafone settlement at 1.25 billion, it may be perfectly logical, therefore, if you're not a tax expert, for you to give senior lawyers within your area a degree of discretion. What I'm trying to establish is whether they advised, with their expertise, that the 1.25 billion pounds was the correct amount.
And my answer to that is, as before, that I can confirm that lawyers were involved throughout, but I cannot go into any more. So
you can't confirm whether they gave. Okay, could I put it, because I think the quantum is much more important than with Goldman Sachs, because between 2001 and 2011, as far as Vodafone are concerned, we're looking at in the region of £25 billion of profit. And so the actual settlement appears the 30%, obviously it came down in the latter years, but the settlement seems to be strange on a number of levels. First of all, it seems to include the 2011 and 2012 profit. But given that the settlement was reached in 2010, I'd just welcome your thoughts on how they knew what the profit was going to be for 2011 and 2012, given that those profit hadn't been realised. But also, the 1.25 billion looks like it's been based on around 20% of Vodafone's profits, which means the Exchequer may have lost around £8 billion of tax, which makes the Goldmans look quite paltry in comparison. So the reason I'm saying is we're talking potentially, we can't get the figures because Mr. Hartnett won't answer the questions, but we're looking at potentially £8 billion of tax lost. We're looking at a company that was given 5 years to pay, even though it was sitting on a cash pile. And we're looking at a settlement based on future profits which were unknown, even though the department doesn't allow such considerations to be given, and the legislation hadn't been passed by Parliament, so undertakings couldn't have been given by the department. And what I'm trying to establish, Mr. Inglesi, is that whilst you might not be a tax expert and your deputies may not be a tax expert, who from your lawyers was advising Mr. Hartnett to ensure that we can satisfy ourselves that that sum for £1.25 billion was correct?
I'm afraid I can't comment on that.
Why not?
Because that is covered by legal privilege and I can't comment. I would like to say something about the fact that you keep on mentioning tax expertise. Can I do my job without being a tax lawyer? Of course I can.
But we don't know what involvement they have. That's the issue. We don't even know if interest was charged on this 1.25 billion. One assumes it wasn't because Vodafone released, I think, 900 million that they had set aside. They stopped setting money provisions aside in 2006, incidentally, probably assuming they were going to win the case, and then found that they didn't. And would have had to set aside far more had they known they were going to lose the case. But this 1.25 billion, we don't even know what interest that included. Are you able to tell us what interest that included?
I can't comment on any of that.
But who were the experts from your department that were providing the tax legal advice to Mr. Hartnett?
All I can say is lawyers involved throughout, and that's all I can say.
In terms of Vodafone, could you just clarify with the settlement, was any discretion exercised over the 1.25 billion, or was that the correct amount in law?
Yeah, I'm afraid I cannot go into that. I can't comment on that.
Well, I'm just asking from a legal process point of view whether any discretion was exercised or not.
I can say at a general level, when a settlement is reached, it's reached by agreement.
But Mr. Harnett said no discretion was exercised. He did not take a penny less than the correct amount in tax. Just as a matter of law, I just wanted your confirmation that is correct, is it?
That's my understanding, that it's correct.
So no discretion over interest was exercised?
My understanding from speaking to all my colleagues is that the Vodafone settlement was correct.
No one would want civil servants to break the law, of course, so that's a statement of the obvious. If there's a gateway that permits disclosure, they wouldn't be breaking the law, would they?
No.
So could we come to the point as to what in statute prevents you from disclosing information to Parliament?
Well, I will be governed by the professionals on that.
Mr. Barclay, I think as I've said before, we agreed at the last hearing that providing assistance to Parliament is one of our functions. But it's quite a big step from there, providing assistance, to actually providing a detailed information about individual taxpayers. And I think we explored before, and this is in my letter to the Chair, I can't remember the date, Ma'am, I'm sorry, but when I set out the law around taxpayer confidentiality, that the commissioners of Hmrc have a role in determining the approach to taxpayer confidentiality, and they have in 2009 made a decision about that. I think as well we explored very tentatively last time whether there was a way of having confidential briefing for the committee which maybe was manageable within the general strictures, but didn't become public.
Sure. I mean, those are different issues. If a mistake has been made or the law has been broken, does Parliament not need to know that so that it can consider whether the law needs to be amended?
Well, I think taking a mistake that we have discussed before, Parliament does know about it because the NAO reported it.
No.
But we don't know the size of the mistake. We don't know the value of the mistake.
Well, I think with respect, didn't Mr. Morse give you a number at the last hearing?
No, well, what we're trying to establish is the legal position rather than what the NAO view is. From a legal position, in terms of statute, could I come to the question I put to Mr. Inglesi? Is there any distinction between identifying and non-identifying information in the 2005 Act?
I cannot recall a clause that says that, but I mean, we have, it won't surprise you, Mr. Barclay, looked back over tens of years, decades even, about how taxpayer confidentiality has been applied, and it has constantly been applied like that. And this is back to your point about the role of the commissioners, and the commissioners have made a distinction between identifying and non-identifying.
Sure, but we weren't looking at the historic legal position. You've been quoting the 05 Act. The 05 Act doesn't draw a distinction, so it's policy reasons which go to the heart of why you're not disclosing. And the point is, you have a discretion, but the argument you have been putting repeatedly is by law you're prevented by the 2005 Act from disclosure, and yet the 05 Act has a gateway. So do you accept that you're not prevented from disclosure by the 2005 Act?
All my advice, Mr. Barclay, so far has been that I am prevented, and my colleagues are prevented, by the Act and by the decision of the Commissioners. Even when information's in the public domain? Even when information is in the public domain, unless it is in the public domain lawfully.
Well, appearing in Vodafone's company accounts, one assumes, is lawful disclosure in the public domain, is it not?
Well, I mean, it frankly depends what appears in Vodafone's accounts.
Responsible.
I mean, you refer to that in your letter of the 19th October. In fact, one of the reasons for not disclosing to Parliament is because you also don't disclosed to ministers.
No, we don't disclose individual tax matters to ministers, that's right.
Why is that? Because
That's quite right.
surely ministers all the time are coming into information of various forms.
No,
So if there's a conflict of interest, you would get another minister to act.
No. Well, you could argue, if you want to go down that route where we give ministers access to individuals' tax records, I would strongly oppose
We're
that.
not talking here about individual people. We're talking about large corporates. I mean, this is likewise the nonsense in this letter which says about the European Court of Human Rights. We're not talking about people's family life. We're talking about the settlements with large corporations.
But what if it's an individual who's in charge of a large corporation?
Sure, and you have that within the governance. But the two cases we're trying to get to in terms of these hearings, which are Vodafone and Goldman Sachs, are not dealing with individuals in terms of their family life. We're not talking about sole traders. We're talking about large corporations, and yet this letter sets up a number of policy red herrings where they could be managed in other ways. I mean, likewise, one of the other reasons is you put forward is that it has a damaging effect on other government departments. Well, if a company is breaking tax law, why is disclosing that damaging on other government departments? Could you give me an example of how that would be damaging on another department?
I'm just trying to think of an example of where disclosure could impact on another government department. It may be that, Mr. Barclay, we learned something through our inquiry,
I can give you some examples where there have been tenders for contracts where a number of companies involved, and one of them may well be in a situation where they're in litigation, or they're in where actually.
So the individual minister has a conflict. You get another minister to do it. That must happen all the time.
I haven't mentioned a minister at all. I'm saying there's a procurement issue, right, that a department's dealing with may have gone nowhere near a minister, right? Procurement issue where you're talking about a tender, and where one of those companies is actually in a very difficult place with Hmrc. Now, there's some really difficult issues for us as to how we handle those sorts of issues.
Stephen.
As Austin's raised Mr. Inglese's evidence, could we just come back to the chronology?
Of course.
As I understand it, Mr. Inglese said that you first raised the error with him on the 7th of December. Okay. And yet, at our last hearing, in reply to Richard, you indicated that you told him on Monday the 22nd November.
I think I said several things, Mr. Barclay, in an attempt to be helpful. Would it be helpful if I set out the chronology?
Yep, if you want to take us through. Just to refresh your memory, when did you speak to Mr. Inglese? I think on Monday, but I need to check, Mr. Bacon. Yeah. You think it was the 22nd after the Friday, very soon after, yes.
Okay. Well, and there was another passage when I said perhaps it was the week later as well. The meeting with Goldman's was on the 19th of November. Yep. Over that weekend that followed, our banking sector lead became concerned that a mistake had been made in governance. It's really important that I stress in governance. He concluded that the matter had to go through our high-risk corporate governance process and discuss the matter with his director, who agreed that should happen. At the same time, I began to have a nagging doubt about the interest position.
When you say at the same time, over the weekend? Over
the end of that weekend.
And was the banking sector lead at the meeting on the 19th?
Yes, he was.
Yeah. So both of you were at the meeting, but neither of you spotted the error at the meeting?
On the interest?
On the 19th?
No, I mean, not at all. In the week of the 22nd, I mentioned to Mr. Inglese that I had settled, or we had settled, or whatever the right term is, one of his litigation cases.
And that was when, sorry?
That was in the week of the 22nd of November.
Yep.
Thank you, Mr. Bacon. I didn't say more because by then this issue of the interest was going through the high-risk corporate programme, and which was our governance mechanism. And I think it's a matter of history now that the high-risk corporate programme rejected the settlement. The papers for the high-risk corporate programme were prepared by the banking sector lead and the customer relationship manager responsible for Goldman's, and brought out the interest issue. I was abroad on business the following week. I think Mr. Bacon brought out all my movements at the last hearing around this time. I was abroad on business for the whole week and was informed while I was away that the high-risk corporate programme had rejected the proposed settlement on adjustable options because of the interest issue. On returning to the UK, I spoke to Mr. Inglese on the 7th of December, and I asked for his advice as to what the options were in relation to the Goldman's interest issue, and he went on to give me advice, or as Mr. Mitchell has described, that there were two options. And that having gone back and looked at it all, I was trying to be helpful before.
No, that's very helpful. There's a slight tension in what you're saying between, on the one hand, in the week commencing 22nd, saying, as you do, that you notify Mr. Inglese that you had settled his case, whilst at the same time saying that by then you had also identified a flaw in the settlement. Would it not be normal, when referring to a litigation case with your general counsel, to say, I have settled the case, but I've spotted a mistake?
Oh, I've no idea what would be normal, Mr. Barclay. I mentioned it to Mr. Inglese, and I was confident that this matter was going to be explored by the proper governance process.
No, but the point I'm driving at is on one hand you're saying you spotted the mistake over the weekend, and yet the following week you're saying to General Counsel, we've settled it, but not telling him there's a mistake. It just seems inconsistent.
Because I wanted to be sure, as I said to you, I had a nagging doubt. The high-risk corporate programme board, with lawyers on it, went on to examine that issue on the 30th, I think the 30th of November.
Yeah. So there were no lawyers, I think we established at the meeting on the 19th.
There were no lawyers for HMRC.
No, so when the banking sector lead and yourself spotted a mistake, this was a mistake?
There were different mistakes.
These were two different mistakes?
Yes, I've said that before.
Sure. And in terms of the file note, because at both your last two meetings you said you hadn't actually found the time to read it, I assume you have.
Well, it wasn't a question of finding the time to read it, Mr. Barclay. The issue was being managed by the banking sector lead and the customer relationship manager.
Sure. I think actually you did say that you no, not yet, but I will do so.
And I went and found it.
I have not yet had a chance to check.
But I went and found
the
it.
second hearing. Marvellous. So, having now read it, Sir Gus mentioned the importance of transparency.
Mm-hmm.
Was a note of this settlement meeting, of such importance that you phoned in advance the head of global tax at Goldman Sachs, a very senior post, to fly over from New York? Did HMRC produce a note of that meeting?
I don't think so, because...
Don't think? Have you not checked?
Well, I haven't found one, Mr. Barclay. I haven't searched for it. I've asked.
Sure.
But the important issue is this. What the team said to me is that the note from Goldman's about what had taken place came in very quickly. I've seen that note, and they found it an acceptable note of what had taken place.
That's right. But is it reasonable to conclude, therefore, given that this is your third appearance on this same issue before the committee, that if you've not to date found one, there was not a note produced?
I don't think HMRC produced a note of that meeting.
Right. Is it not odd, given the importance on transparency emphasised by Sir Gus himself, that settlement meetings attended by yourself as tax commissioner are going ahead without a note being produced?
But that's because the team thought the Goldman's note, which came in very fast, was acceptable.